All right. Could we first please have Mr. Blessing Nelson and Mr. Glenn put your appearances on the record?
Yes, Austin D. Blessing Nelson for the grievance administrator.
And good morning, Your Honor. Luther Glenn, appearing pro se.
Morning. This is a pre-hearing conference pursuant to MCR 9.115 F4C, being convened virtually via Zoom video conferencing before Tri-County Hearing Panel number 15 of the Michigan Attorney Discipline Board in the matter of Grievance Administrator v. Luther W. Glenn Jr., P number 38683, case number 24-77-GA. The panel is comprised of me, Lynn Helland, chairperson, Patrick McLean, member, and John Cawthorn, member. The panel has been appointed by the Attorney Discipline Board, the adjudicative arm of the Michigan Supreme Court, for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. Counsel for the grievance administrator is Austin D. Blessing Nelson, who will present the case for the Attorney Grievance Commission, which is a separate branch of the Michigan Supreme Court for the investigation and prosecution of discipline matters. As this is a hearing being conducted via Zoom, hosting controls of the meeting will be performed by the case manager, Jody Groh. The hearing will be live streamed on the board's YouTube channel, and the parties are asked to avoid excessive over-talking and interruption to keep the proceedings moving smoothly. This hearing will be conducted according to MCR 9.115, the rules for circuit court bench trials and the Michigan Rules of Evidence. In accordance with MCR 9.115J, the hearing panel must first determine whether misconduct charged in the formal complaint has been established by a preponderance of the evidence, by respondents' admissions, or as the result of respondents' default for failure to answer the formal complaint. If, at the conclusion of these proceedings, the panel determines that misconduct has not been established, the proceedings will be concluded and the complaint dismissed. Upon a finding of misconduct, the hearing panel will conduct a separate hearing to determine the appropriate discipline. At that time, the panel will consider evidence which is admitted for the purpose of showing mitigating or aggravating factors. The decision of this panel may be appealed to the Attorney Discipline Board by the grievance administrator, the respondent, or the complainant. And we will now proceed with the hearing. Mr. Blessing Nelson, I'm sorry. Let me begin with you.
Sure. As a preliminary matter, I just want to point out, it was brought to my attention that unfortunately there is a error in paragraph 4 of the formal complaint. It says that Mr. Glenn became licensed in 1982 and lives or works in Cass County. Unfortunately, that is incorrect. It should be 1986 and Wayne County. Fortunately, it appears the correct hearing panel was assigned. I apologize for this mistake. I would request that that be deemed amended. I can file a new one if need be, but I would ask that that date back to the original filing date.
Mr. Glenn, any objection to amending the complaint?
Well, I was defaulted in this matter, and I filed a motion to set aside the default. I would respectfully ask the court to require that the complaint be amended and the panel accept my filing to the answer.
Okay, so breaking this down into its separate parts, I hear you have no objection to amending the complaint.
Well, as long as the default is set aside. So
yeah,
okay. I'm going to I'll deal with those two questions one at a time. Mr. Glenn, I then understand that you object to amending the complaint. Is that correct?
Correct.
Okay. Can you explain to me how you are prejudiced by amending the complaint?
Well, it's amending it without formal pleadings on this matter. The allegations in the complaint go straight to, it has parties in jurisdiction. So in my opinion, that's not a small area in the complaint. That's something that needs to be formally amended.
Okay. Let me just ask either of my panel members to disagree with me if they're so inclined, and we'll go to a breakout room. But my inclination is to grant the motion to amend the complaint on the basis that this is an amendment in form, but not in substance.
I think we have to talk about this. Yeah, can we go to a breakout room?
Yep.
One moment.
Mr. Blessing Nelson, are you there?
Yes.
And Ms. Kaminsky, are you ready to proceed?
Sir.
All right, a couple of things. One, it was pointed out to me when we went off the record that the opening statement I read actually applies more to a hearing. I want to clarify, this is a pre-hearing conference that we're having today. It is not the actual hearing.
I had wondered about that. It did seem like there was some misconduct hearing language there.
Yeah, that's on me. I was reading the wrong language. And we also had a chance to talk through the situation with respect to the complaint. We now have a new complaint, and because we have a new complaint, there is no default.
No, under the court rules, amendments can date back to the original filing.
Well, okay. I think I go ahead, make your argument.
Okay, court rules. Okay. Let me find the court rule. I have it cited here. 2.11. Let me find that. Just give me 1 second to find the court rule, because I had planned to use it, but I'll
Whether
just
it dates
say
back is irrelevant. He still has to answer the amended complaint.
you have to answer the amended complaint, but only to the extent it's been amended. I'm amending 1 paragraph. I'm not amending the full thing. Here we go. Amendments.
If he timely answers your amended complaint,
No, that would not undo his default. MCR 2.118, specifically I'm seeking under 2 to amendment it. MCR 2.118A4 amendments. Oh, wait. I'm sorry, 2.118D. An amendment that adds a claim or defense relates back to the original pleading if the claim or defense asserted in the amended pleading arose out of conduct, transaction, or occurrence set forth or attempted to set forth in the original pleading. I mean, honestly, it doesn't even directly address this. I'm not adding a thing.
no, you're not adding a new claim.
No, and there's nothing in here saying it doesn't date back. And honestly, I'll be completely honest. Did not have to come in here and I offer to amend this. I could have left Mr. Glenn to his proof. And contrary to what he said, he did not file a motion to set aside the default. The default.
Well, let's not proceed to that, because we're still talking about whether or not the complaint has been amended. And I'm not hearing a court rule that clearly says that the amendment dates back to the original and doesn't affect the timing of the proceedings. So
There's no court rule saying it doesn't.
Okay, but that's not going to work for us. We're going to want a court rule that is clear. Otherwise, as far as we're concerned, we have a new complaint, and that requires an answer. And Mr. Glenn has an opportunity to answer it.
MCR 2.118B, response to amendments, reads as follows. Within the time prescribed by MCR 2108, a party served with an amendment to a pleading requiring a response under MCR 2110B must 1, serve and file a pleading in response to the amended pleading, and serve and file a notice, or serve and file a notice that the party's pleading filed in response to the earlier pleading will stand. So the court rule puts the onus on the respondent to respond. But he does get to do that. So if you're going to amend, that's fine, and we think that's probably a good idea. But
No, in that case, I will respectfully withdraw my motion to amend. I'd ask Mr. Glenn that he make a motion. Quite frankly, here's where I'm at. Quite frankly, Mr. Glenn filed an answer to the formal complaint pointing out a single defect in my formal complaint. He filed an answer that admitted 3 paragraphs, but improperly claimed lack of knowledge to the rest of the formal complaint. The answer is not proper. The default.
But he answered it
you
different.
asked on the record. You asked on the record to amend your complaint
I did, but I did under
on the day of hearing.
I asked to amend it to conform with. I asked to amend it to correct what, quite honestly, was an unfortunate typo. This hearing panel was properly assigned. I asked to amend it on the understanding that it would date back and not affect the default, which quite honestly relates to Mr. Glenn's professional obligations.
Why do you need to default in this case anyway? Why can't you just prove your case?
That's neither here nor there. I'm entitled to a default if Mr. Glenn does not timely and properly answer the formal complaint. He then has an obligation to set the default aside. I could prove this case about the default.
We all understand that, but an amended complaint's a new complaint. And if he answers it timely, it's at issue.
So that's where we are.
Okay.
So
We're not comfortable with defaulting the respondent when there might be some substance of a response. We want to hear the merits, not technicalities. Anyone would.
Mr. Blessing Nelson, I know you're not real enthused about this, but for what it's worth, I think it's probably to your benefit that we dot every I, cross every T, and let this process play out with every I dotted, every T crossed. So that's what we're going to do.
Okay, I respectfully disagree. It's in the sake of judicial economy for default, but I respect the panel's decision on that. And okay, when should I file the amended complaint by?
Well, I think you amended it today. I mean, I guess I would consider.
We haven't seen it yet. He's going to file a piece of paper that's an amended
Okay.
complaint. He described it for us, but we haven't seen it.
Okay, let's file it today if you can. Let's get the process moving.
I can try to get it filed today. Yeah, I would ask that the panel set a deadline for Mr. Glenn to respond to that bot.
The court rules do that. He has X days to respond to a complaint. If he's late responding to your amended complaint, I'll be flabbergasted. But if he does that, he could be defaulted again.
Okay. Okay.
Mr. Glenn, respond to his amended complaint timely, please. Do that.
Yes, sir. Yes, sir.
And just to clarify, is it the panel's interpretation of the court rules that Mr. Glenn has to respond or has a right to respond to the entire formal complaint, including changing his original answers to things that I'm not amending?
You can always do that. When there's an amended complaint, you can always raise whatever you want to raise. Now, if there's inconsistencies with what you have said before, that can go to credibility, that can be raised. You can certainly point out later, if it's to your advantage, that Mr. Glenn has said X and not X. But he has to respond to your amended complaint, which he hasn't seen in writing.
Okay, I
Okay?
can file that today.
Okay, and yeah, and whatever day you file it, whether it's, we're not setting a deadline for you to file it. But whatever day you file it, he has what the court rules provide him to answer it. We trust that he will. And then once there's an answer, whatever it is, we'll take it from there.
Okay, and just to make sure that all our T's and I's are crossed and dotted, is the panel formally setting aside that default? It's being
There's-
deemed moot.
We don't think we have to deal with that because you're amending.
Respectfully, some ruling needs to be made on it. It has been filed. Whether or
Okay,
not the panel deems it moot, to
Then,
preserve the issue, if I do decide to file an appeal, something needs to be ruled on.
On the record, you asked to amend and we're letting you.
so I would say that your amendment moots the default and the motion to set it aside.
Thank you. And just for the record, no motion to set it aside was ever filed. And that does need to be in writing because it needs to have a statement of meritorious defense.
I understand there was a motion.
Yeah, I have here a motion to set aside the default that I
One was
received
filed this morning.
this morning.
It's very
If
short.
that was filed, it was not properly served on me because I never received it.
Okay,
It's
but
going to
we'll
be
find-
mooted by
Right.
your amendment anyway.
Right.
Correct, but I would just want to know that that was not properly served on me and should not be considered. It
Okay.
is moot, but
And we're
For the
not
record.
granting that motion to set aside. We aren't considering it.
I know, but
It was
to make
filed.
sure record's clear, that motion was not served on me. I just want to make that clear.
Okay. All right,
Okay.
but Mr. Blessing Nelson, it's better this way. The Attorney Discipline Board doesn't want to hear hyper-technical arguments about default procedure. It's going to want to know what happened or didn't happen here.
Respectfully disagree, but I defer to the panel.
Okay.
And Mr. Glenn, this is gratuitous, but I hope you've heard the conversation we've had about timely filing, proper service, and as we move forward, those are issues we won't have to deal with.
Yes, sir. Understood.
All right. Then unless there's anything further, I believe we are done here today.
I would request that we set a hearing date.
Well, do we need an answer to the complaint before we do that?
Well, I'm filing it today. He has, I believe, 21 days to
21
answer.
days.
So we'll know within 21 days if he answers or doesn't. Regardless of his answer, I mean, given the allegations, I'm not going to need any more time to prepare based off his thing. I request that we set a hearing date and some motion deadlines, and get this ball rolling.
Well, okay, I think we all agreed to get a ball rolling. How about, though, what we do is, and again, my co-panelists, tell me if you feel differently. Well, I think we should set a pre-hearing conference date so we can understand what this eventual hearing will look like. I'm not sure we can do that until we have an answer to the complaint.
And a complaint, because there's no statute of limitations at all. And in theory, the complainant could wait a long, long time and then file an amended complaint. So let's have an amended complaint and an answer within 21 days. Then we're all set.
I mean, if that's how the panel proceeds, I'm okay with that. But just to be clear, I am representing to you that I'm filing the amended complaint today. It will not be filed whenever. I'm also telling you that based off the allegations in the formal complaint, which are straightforward and relate to failure to answer RIs, that I can tell you exactly what the hearing will look like, how many witnesses I will have, the type and relative number of exhibits that will exist, and everything regarding that. And Mr. Glenn has already seen the formal complaint, which will be amended with one single paragraph. So I respectfully think we could set all the deadlines and stuff today, but if the panel wishes to do another pre-hearing, I will defer to the panel on that decision.
You know, we know that it's in your interest to get it going fast. We expect you to file it today. We're not saying we don't believe you won't file it today. We think you will, but maybe Mr. Glenn will hire counsel. Maybe there will be another set of eyes on the case. Let's do it right.
All right. That I agree. I dotting, T crossing. We're going to move this along, but we're going to do it a step at a time.
Okay.
Thank you. All right. This hearing, pre-hearing conference is adjourned.
Thank you.
Thank you.
Lynn, can you and Pat stay for a second?
Yes.